Welcome back to another intense day in the courtroom, where patience is thin and the excuses are even thinner. Today, we are looking at a docket that is absolutely overflowing with bad decisions, dangerous driving, and defendants who just don't know when to quit. We're talking about a lineup that includes everything from crashing a car into a city bus to getting high on nitrous oxide behind the wheel, and even someone slamming their vehicle into a moving train. You literally cannot make this stuff up. But the real star of today's video isn't the crimes. It's the judge. You are about to see a masterclass in judicial roasting. We have a defendant who picks up a new DWI while already out on bond for a previous DWI, leading to one of the most legendary lectures we have ever heard. The judge literally invokes divine intervention, telling a defendant that even if Jesus himself needed a ride to church, this guy isn't allowed to drive him. We're also going to see the heartbreaking reality of addiction, the financial nightmare of Texas surcharges, and a woman who decided to physically fight a police officer to save her boyfriend from arrest. Stick around because we are breaking down the legal strategies, the massive failures in judgment, and the harsh reality of what happens when you test a judge who has heard it all. Let's get into the docket.
You are on bond for DWI, and you've now picked up a new DWI. Sir. You were charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officers spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled.
Let's pause here to appreciate the sheer level of negligence involved in this first case. Legally speaking, being on bond is a contract with the court. You promise to behave, and they let you stay out of jail while your case is pending. Mr. Gayos here didn't just break that promise. He shattered it by allegedly driving drunk again and crashing into a city bus. The witness testimony here is damning. Striking a bus, getting stuck, and then trying to physically push his car away before fleeing? That is flight risk behavior 101. In the eyes of the court, a defendant who picks up a new charge of the exact same nature while out on bond is the definition of a danger to the community. The judge is hearing this probable cause and likely already calculating a bond revocation. Let's see how the judge handles this massive violation.
Another law enforcement officer was alerted to the incident and found the defendant who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus. Another law enforcement officer made contact with the defendant who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant. The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me?
Yes, sir.
On one ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI.
Yes,
I'm
sir.
revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we waive
So-
the fees?
Absolutely, of course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond to him?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Wow, you just heard it. If Jesus comes from heaven and needs a ride to church, you drive. I can have a contempt hearing. That is an absolute Hall of Fame line from the bench. But strip away the humor, and the legal reality here is terrifying for the defendant. The judge is imposing an ignition interlock condition and a total driving ban. This means if Mr. Gayos even sits in a driver's seat without blowing into a breathalyzer, he goes back to jail. The judge is closing every single loophole. He's removing the necessity defense, the idea that you had to drive for an emergency. By explicitly stating there are no exceptions, he is setting a trap where any violation results in immediate contempt of court. This is what we call zero tolerance in action. Do you think this strictness is necessary for a repeat offender? Let me know in the comments.
I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. I'll set the bond and then,
Take my card here and
Look, I asked you to start moving around. We'll handle this when I do get the.
All right, Judge.
get whatever date you want on the new cases.
Okay.
When he posts bond on the old case, feel free to get in touch with the, and then you can put the date
Just
for
one
whatever.
together.
Yeah,
What are
He-
you setting the bond at? I'll tell it.
5,001.
5,001.
Yeah.
Cases or just legal?
He just, no. The two new ones, I'm not gonna touch. I'm gonna leave it as is. But he's made a bond, so we're only gonna do the old DWI, 5,001. Actually, we're gonna need, he signed conditions now, so when he gets out, he'll
We'll
have,
have that.
yeah,
Okay.
because we'll give him a copy of the conditions now.
Okay.
So they just feel free to let her, whatever date you get,
Okay.
after
And
he
then
gets out,
once it's
just
out.
yeah.
Okay.
Hi,
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne? What were
They
the,
were presumptive positive for THC.
that's it.
That's it.
Okay, I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
Well, he tested positive on April 7th, Judge, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the,
I ordered him not, let me see, hold on. I ordered him not to use in January. We are now,
yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
if I tested him in early January, then I'm gonna have an issue. But if it's the first time I tested him was in April, then I'm gonna give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm gonna have an issue.
Okay.
I don't remember when the first time we tested him, so I'm gonna ask her. Roxanne, on Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
Okay. So March 11th was the first test and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when he was a no-show. And on April 14th, it was confirmed by lab that he was positive.
No, you're using. I'm sorry. I'm revoking your bond.
This is a classic courtroom battle. The residual THC defense versus the zero-tolerance judge. The defense attorney, Ms. Schlossberg, is making a valid scientific argument. Marijuana stays in your system for up to 30 days, so a positive test in April could be from use in March. However, the judge isn't buying it because of the timeline. The defendant tested negative in March, then positive in April. Legally and logically, you can't go from negative to positive without introducing new drugs into your system. The defense is trying to save the bond by blaming biology, but the judge is looking at the black and white data. The judge is about to make a ruling based on the concept that a bond is a privilege, not a right. If you can't follow the rules, you lose the freedom. Let's see if the defense can talk their way out of this revocation.
You're going into custody.
I could just ask the court Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother, who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that, but there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really. If I don't, I'm enabling the behavior, and that's it.
Yes, sir. Maybe excuse me.
Please. Good morning, Mr. Galvan.
Good morning.
The judge stood his ground. If I don't, I'm enabling the behavior. That is a powerful statement. Courts often struggle with this balance. Do you punish the addict, which often hurts the family, like the mom paying the bond? Or do you enforce the rules to ensure public safety? The defense attorney fought hard, essentially guilt-tripping the court about the mother losing her money, but the judge recognized that letting him walk after a confirmed negative to positive test makes the court's orders a joke. It's a harsh outcome, immediate jail time for smoking weed while on bond, but in a strict Texas courtroom, it's the expected outcome. What do you guys think? Is revoking bond over marijuana use too harsh in 2025, or did he deserve it for breaking the rules? Sound off in the comments below.
You were charged with driving while intoxicated. You were facing up to 6 months in jail and/or a $2,000 fine. Do you understand? Are you sure, or would you?
He's just a little bit embarrassed with the situation, Judge, of being here for the first time.
Do you prefer a translator, or?
Well, I understand what you just telling me, yes.
Okay. We are going to do probable cause. We need to know what happened in the case. You have the right to remain silent. Anything you say can or will be used against you. Okay. Ready?
Yes, Your Honor. Thank you. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 74 miles per hour in a 45 mile per hour zone via radar. He observed the vehicle stop beyond the designated stopping point at a red light and make a wide right turn. The law enforcement officer initiated a traffic stop and observed the defendant to be the sole occupant of the vehicle. The law enforcement officer observed watery, bloodshot eyes, slurred speech, and a strong odor of alcoholic beverage. The defendant swayed while standing in place. The defendant's family showed up and stated they drove him home because he was drunk, and they found out he left again, so they went to the location of the stop. Standard field sobriety tests were conducted, A 6 out of 6 was reported on the HGN, a 3 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The defendant refused consent to provide a specimen, and a blood warrant was obtained and executed.
Any RDWIs?
So
Have a license?
he does have a license, Your Honor.
This specific detail is heartbreaking and infuriating. The report states the defendant's family actually drove him home because he was drunk, but he left again and got behind the wheel. This highlights a terrifying reality in DWI cases. Sometimes even a supportive family can't stop a determined drunk driver. Legally, the standard field sobriety tests mentioned, specifically the HGN or horizontal gaze nystagmus, are crucial. When the officer says 6 out of 6 clues, they are referring to the involuntary jerking of the eyes. You cannot practice beating that test. It's a physiological reaction to alcohol. Between the high-speed 74 in a 45 and the failed tests, the probable cause here is rock solid. The court has no choice but to treat this as a serious threat to public safety.
No prior DWIs, Your Honor. I'm running his license, although.
Mr. Galvan, I'm going to find that there's sufficient probable cause to go forward with your case. Hay suficiente causa para continuar con tu causa, ¿ok? No puedes tomar alcohol, illegal drogas, y te voy a hacer examen. Si tomas o si usas, te pongo en la cárcel. ¿Me entiendes? Tú tienes un abogado, no tienes que venir a la corte hasta que él te dice. Pero si él me dice que no puede contactar y tienes problemas, voy a revocar la fianza. ¿Me entiendes? Tú no puedes manejar si no tienes una licencia y también aseguranza en tu nombre. All right?
Thank you, Your Honor.
So, for now, we will have you sign a reset. Vas a ir con Roxanne de Pretrial Services y ya te puedes ir.
Y no se tiene que presentar para próximas cortes.
Muchas gracias.
You are Joe Castillo. Jose Castillo.
Sorry. Jose.
Castillo, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 23rd, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 77 miles per hour in a 35 mile per hour zone via radar detection and weave in and out of lanes around 4 vehicles, nearly causing a crash. The law enforcement officer briefly lost sight of the vehicle, but found the vehicle parked sideways in a driveway close by. The defendant was still inside the vehicle.
This sounds like a case ripped straight from the headlines regarding street takeovers. Doing 77 miles per hour in a 35 miles per hour zone while weaving through traffic is not just speeding. That is reckless endangerment. When you hear the judge later warn about donuts and racing, he's addressing a specific plague on modern roads. In Texas, they have cracked down hard on street racing and exhibition driving. The fact that the officer found the car parked sideways in a driveway suggests a desperate attempt to hide after a high-speed chase. The defendant admitted to driving but claimed he was only going 60, which, by the way, is still nearly double the speed limit. That is a terrible admission to make to a cop. Never give the police the evidence they need to convict you.
And admitted to being the driver, but stated he was only going 60 miles per hour.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I'm now also ordering you not to drive in a reckless manner, not to participate in any street takeovers, racing, anything of this nature. And if I find you do, I will put you in jail. No more PR marks. Do you understand?
Sure. It's out of the way, Your Honor.
How old are you, sir?
18.
What do you do for a living?
We're connected to the warehouse.
Okay. Do you have the ability to hire a lawyer? You want a court-appointed lawyer?
Under the request of attorney.
Okay. I need you to fill out an application for me. Deputy Miranda is going to give an application. I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box. Do not leave until you sign all our bond conditions. You understand? Come on. Do you mind filing those conditions, please?
Yes, Your Honor. That'd be no reckless driving and no driving.
Same
without a
as-
valid license.
And then no racing, street takeovers, donuts.
Yes, Your Honor.
You're Alexa Mendoza. Ms. Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 23rd, 2025, law enforcement officers were dispatched to a traffic collision in Harris County, Texas. The officer observed the defendant's motor vehicle on the fixed rail tracks impaled to the LRV. The law enforcement officer opened the door to check on the defendant, the sole occupant of the vehicle, and observed the defendant to be impaired. The law enforcement officer observed glossy eyes and slurred speech, and the defendant stated she left a bar where she had 8 to 10 drinks of tequila and was on the way to a concert. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN. The law enforcement officer notes that the defendant threw up during the HGN. The walk and turn was a 4 out of 8, and the one leg stand was a 3 out of 4. The defendant was ID'd by her Texas driver's license, and the defendant consented to a breath test yielding a .137 and a .123.
Any prior DWIs?
No, Your Honor.
Did you catch that? She crashed her car into the light rail vehicle. She hit a train. The level of intoxication required to not see a train on fixed tracks is staggering. The report says she admitted to 8 to 10 tequilas. Legally, that admission alone is enough to convict, but the physical evidence is overwhelming. She actually threw up during the eye test, HGN. In the world of DWI enforcement, vomiting during a sobriety test is essentially a game-over moment. It shows a complete loss of bodily control. On top of that, her breath test results were .137 and .123, which is well over the legal limit of .08. This isn't just a slip-up. This is a catastrophic failure of judgment that could have derailed a train and killed people.
License?
Check that.
Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If you test positive, your bond will be revoked. You'll go into custody. You understand?
Yes.
You are not allowed to drive unless you have a Texas driver license and liability insurance in your name. As long as you have those, you may continue to drive. Just don't use. Do you understand?
Yes, sir.
It is helpful, Your Honor.
Great. Because you have a lawyer, I will waive your appearance, but you must stay in touch with them and they'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. You'll get with Roxanne for your bond conditions and then you're free to go.
Yes, sir. Thank you.
Thank you. Good morning, Mr. Royalty.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, a law enforcement officer was dispatched to a Shell gas station in Harris County, Texas. Upon arrival, the officer observed the motor vehicle to have crash damaged and to be disabled and inoperable. The law enforcement officer observed the defendant sitting in the driver's seat. The law enforcement officer observed constricted pupils, slow speech, and unsteady balance. The defendant stated that he was driving his vehicle before the accident and that he does not know what he wrecked into. The defendant stated he did not know where he was coming from before the crash. The defendant stated he consumed 1 alcoholic beverage. He also stated that he inhaled nitrous oxide approximately 20 minutes before the crash. Standard field sobriety tests were conducted. A 0 out of 6 was recorded on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one leg stand. The law enforcement officer observed an empty bottle of vodka on the driver's side floorboard, an empty vodka bottle inside the center console, and a half empty beer in the back seat. The law enforcement officer observed 3.3 liters of space gas containers of nitrous oxide and 14 1-liter nitrous oxide containers. The defendant is the registered owner of the motor vehicle. The defendant agreed to a breath test strip. However, the law enforcement officer notes that there was an interferent error and the breath test was unable to be collected. The law enforcement officer called for a drug recognition expert who completed an evaluation. The drug recognition expert stated the defendant is under the influence of cannabis and is unable to operate a motor vehicle safely. The defendant consented to a blood test and a sample was collected.
This case introduces a dangerous trend we are seeing more often: nitrous oxide, or whippets, combined with alcohol. The officer found empty vodka bottles and 14 containers of nitrous oxide. This creates a terrifying cocktail of impairment. Nitrous cuts off oxygen to the brain, causing instant disorientation, while the alcohol slows reaction time. The interferent error on the breath test is interesting. It likely means the machine detected a substance that wasn't just alcohol, or the chemical composition of his breath was so messed up from the gas that the machine couldn't get a clean reading. The drug recognition expert, DRE, concluding he was under the influence of cannabis, as well makes this a polydrug case. This man was a rolling chemical weapon on the highway.
Okay. Mr. Royalty, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, and that includes nitrous oxide, whippets, anything of this nature. Do you understand?
Yes, sir.
If I find that you use, I will revoke your bond, put you in jail, no more PR bonds. Any priority to PIs?
No priority to
License?
eligible.
And you may continue to drive as long as you have a license and liability insurance in your name. If you don't have either, then you're not allowed to drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
Okay. I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Miranda is going to give you the application. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir. Sir, please. Why does this keep happening? Over and over and over. Why does this keep happening? How many cases did you have last year, Mr. Addison?
I have quite a few, sir.
Now, it pled on the 17th of December, and not 3 weeks later, you have now another criminal trespass. How do we stop this from happening?
You I need to leave Texas?
No, we don't want you to leave Texas, but we want this to stop happening. Why would I keep doing this?
Officers don't like me out there, man. They be harassing me. They beat me up. They assaulted me. They put me in the hospital. They tried to kill me.
So why go back?
What do you mean?
Why go back to the same location over and over if you know that they're going to beat you up?
I'm of the state of Texas, not just this area. The state of Texas, the laws don't like me. The police don't like me, sir.
That's baloney because you're a likable guy.
This is a massive shift in tone. We go from dangerous drivers to Mr. Addison, a man caught in a sad cycle of criminal trespass. When the judge asks, why does this keep happening? He's hitting on the systemic issue of homelessness and mental health in the justice system. The defendant says, the law don't like me, and reveals his family is gone. It's tragic. He has racked up 9 cases in a year, likely just looking for a place to sleep or exist. The court system is ill-equipped to handle this. Jail doesn't fix it, and releasing him just leads to a new trespass charge. This is the revolving door of criminal justice. The judge is clearly frustrated, not at the man, but at the situation, trying to find a solution that isn't just lock him up or let him die on the street.
We all like you, Mr. Addison. You seem like a stand-up guy, get nice, but you keep going back. Why would I keep doing this? You know, we hit you with the time served, we let you out, 2 weeks later you pick up a new case. And it's been like that for the last damn year. Where's your family? Who do you have in your life?
I don't have nobody in my life, sir. All my family is dead. My twin just died not too long ago.
You ain't got no kids?
But they grown here, but I can't find them.
Why not?
Because their mother hid them from me.
You ever tried to find them?
Yes,
How?
through the internet. Through the internet, sir.
I don't know, Lori. We're doing the same shots over and over and over. And last year, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases just last year. You pled at the end of December. January, you've got a new case. We let you out. You took off on us 2 more times. And the only reason we have you now is because you picked up an interference. And now we're doing the same thing over. I'm not going to do this. I'm done, Mr. Addison. I'm not going to continue to do this. Plead you to the time served in hopes that you're going to go out there and not do it. No, it's not going to happen. We need to figure something else out.
Take him home with me.
Thank you. That's very sweet. But I'm not going to do this. We need to do what I'm going to do now, what's called a TRAS, to see how we go forward. Because I don't know enough about you and what's going on in your life to figure out how we go forward so you stop picking up criminal cases. I told you that many moons ago that I'm going to stop doing this. And now is the time. I'm not doing it, Mr. Addison. We will set this case for a TRAS. I'm going to try to expedite to get it done as fast as we can. I'm done. What I'd like to do, and the hope is that somehow you, me, and Lori can figure out what kind of family you have in the United States.
Here we see the judge pivoting from punishment to problem solving. A TR usually refers to a transfer to a specialty court or a mental health docket, intended to break the cycle of recidivism. The judge is explicitly saying, this is not a revolving door. It's a moment of humanity from the bench. Instead of just hammering him with jail time, the judge and the prosecutor are looking for family in the U.S. to help him. This is an important reminder that judges aren't just conviction machines. Good ones try to stop the behavior. If they can find his family or get him into a treatment program, it saves the taxpayers' money and potentially saves Mr. Addison's life. It's a long shot, but it's the right legal move.
So that we can get you somewhere where you stop getting in trouble. But it's not working what we're doing. And I'm not going to continue to, this is not a revolving door. Do you understand, sir?
Yes, yes, Your Honor.
That's what we're going to do. So Lori, I'm sorry, but let's set it for a TRAS and we'll come back next week. Lori, Mr. Bueno, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You need to understand that this charge is going on your record. It will be there for the rest of your life. Next time you get pulled over, if you have any kind of funky smell, it's probably not going to go well for you because the first thing officers do, they look at your record. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change it. So you didn't want to do PTI.
Judge, we discussed it and he couldn't get the character letters together and
It's a damn shame, Mr. Bueno, because I'm going to tell you, you had the ability to get this thing dismissed. Now you're pleading guilty to this. One day you're going to look back and say, why didn't I take the time to get it done? This will affect you for the rest of your life.
It's possible.
No, you're now at 200 days. You've done nothing.
This is a cautionary tale for anyone facing charges. The judge is lecturing Mr. Bueno about PTI, pretrial intervention. This is a diversion program that, if completed, results in the dismissal of charges. It's a golden ticket, keeps your record clean. Mr. Bueno apparently was too lazy or disorganized to get character letters together, so now he has to plead guilty. He turned a dismissible case into a permanent criminal conviction because he didn't do his homework. The judge is right. One day he will look back and regret this. A DWI conviction affects insurance, employment, and travel for life. Never squander a diversion opportunity if the court offers it to you.
No, you've had plenty of time to get it done, not on the day of when you're set to plead. The other thing is this, Mr. Bueno, I'm going to tell you that if you come back here with another DWI, it is a minimum of 30 days in jail for anything that you pick up. Not only that, if you continue to endanger the community, a second DWI, it's a $6,000 surcharge. So get ready. If you want to get lit, take find another way, Uber, Lyft, whatever it may be. How do you plead to the offense? Guilty or not guilty?
Yes, sir.
I'm going to find you guilty. I will send it to you to the agreement. I'm going to suspend your license for 90 days, sir. Do not drive until you get a license. Good luck.
Would you be willing to waive the DPS fine?
Yeah.
Thank you, Judge.
Hi, Stacy.
Good morning, Judge. You need this ahead of time. It's a pre-signed waiver, Judge. She already has a copy. I sent her my email.
Got it. Okay.
It's only because he was
Be here now.
he's in the holdover. Yes, Judge.
Have you explained this to him?
So I explained it last time, Your Honor. I tried calling the holdover today because we were under the understanding that he had signed a waiver aside from that one. But if he can step out so he can understand what's going, because I know last time he was.
Please. Do you know the name? Okay. Morning, Mr. Groves.
Morning.
I'm bringing you out just to give you an update of what's going on with your case. You were wanted out of the state of Ohio for a probation violation for I'm assuming that's weapons under disability.
Yes, I'm not familiar with the charge. I don't know what the Texas equivalent is.
The thing is this, Mr. Groves, is that when you sign for probation, no matter where you are, you need to read the fine print. Many times when you sign, you waive extradition by virtue of signing the agreement by saying, hey, if I ever take off, I will refuse to fight extradition. And that's what's happening now. So even if I wanted to give you a bond so you could go turn yourself into Ohio, I can't because you have already waived by virtue of signing for the probation. You understand? So that means that we give the demanding jurisdiction, which is Ohio here, 30 days to come get you. Okay? Okay?
Thank you, Judge.
All right. Thanks.
Thank you, Your Honor. May be excused.
Thanks, Ms. Morgan.
This is a cautionary tale for anyone facing charges. The judge is lecturing Mr. Bueno about PTI, pretrial intervention. This is a diversion program that, if completed, results in the dismissal of charges. It's a golden ticket, keeps your record clean. Mr. Bueno apparently was too lazy or disorganized to get character letters together, so now he has to plead guilty. He turned a dismissible case into a permanent criminal conviction because he didn't do his homework. The judge is right. One day he will look back and regret this. A DWI conviction affects insurance, employment, and travel for life. Never squander a diversion opportunity if the court offers it to you.
Good morning, Ms. Hines.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor. Sorry, I'm having trouble loading it. Okay, here we go. On April 23rd, 2025, in Harris County, Texas, law enforcement officers were dispatched to a suicide. Upon arrival, law enforcement officers found the defendant in the driver's seat of a U-Haul truck, slumped over the steering wheel. The law enforcement officer observed bloodshot eyes, slurred speech, and unbalance from the defendant. The passenger, the co-defendant, was detained and a crack pipe fell out of the co-defendant's pocket. The law enforcement officers found foil with narcotics residue on the passenger seat of the vehicle. The defendant admitted to taking Xanax that morning and standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The defendant consented to a blood test. A wheel witness stated they saw the U-Haul in motion, pull into the driveway of a house across the street, and then walked over to the U-Haul and saw the defendant in the driver's seat.
You said they did field sobriety tests? They take them to the station? What?
Yes, Your Honor. Standard field sobriety tests were conducted. 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and a 0 out of 4 on the one-legged stand.
Blood test, breath test?
It was a consensual blood test.
Any prerogative yet?
No, Your Honor.
This is perhaps the heaviest case on the docket. A suicide attempt inside a U-Haul with drugs involved. It is a desperate, sad situation. But notice the judge's approach. He isn't coddling her. He's giving her a stern warning. I'm going to address it for you, and you're not going to like the way I do it. This is judicial code for, if you don't go to rehab, I will put you in jail to sober you up. It sounds harsh, but in cases of severe addiction and suicidal ideation, jail is sometimes the only place where a defendant is forced to be sober and safe from themselves. The judge is putting her on a short leash, testing her within a week, to force immediate change.
Signs I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it, because I'm telling you, if it becomes a problem while you're on bond, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I'm ordering you not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you, and I'm going to test you probably within a week. Do you understand?
Yes, sir.
Do not use. If you have a problem, now is the time for you to do whatever you need to do to address it. You have the ability to hire a lawyer, ma'am.
No, I don't think so.
Okay, I need you to fill out an application for me, and I'll take a look to see whether you qualify. I will have you go, oh, you said she has a valid license?
It is eligible.
Okay, you're also not allowed to drive unless you have valid liability insurance in your name, and that is also a condition of your bond. Do you understand, ma'am?
Yes, sir.
So I'm gonna have you go to Victoria, sign a reset. Deputy Miranda is gonna give you an application. I need you to fill it out for me. When you're done, you can bring it back to us and we'll take a look. Please.
Your Honor, I'm here on a plea this morning for Jose Traconi.
Okay, are you ready?
Yes, sir.
Do you mind bringing him up? Good morning, Mr. Traconis. You speak English, right?
Yes.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. The next time you get pulled over, you smell like alcohol or dope, an officer's going to see this DWI. It's probably not going to go well for you. So don't give them the ammunition. Don't get into a car, even if you've had a sip. Do you understand?
I understand.
Bring up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, or give up the right to appeal. Once you plead guilty, there's no change in this. Is this what you want to do?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
Mr. Traconis, I want you to understand that from now on, what we're doing today, you're facing a minimum of 30 days in jail from now on if you ever pick up another DWI, not to mention a $6,000 surcharge that tacks on to you. And if you don't pay it every day or every $100 you owe, you sit 1 day in jail. Do you understand?
Yes, sir.
Okay. I'm going to suspend your license for 90 days.
Listen to the financial reality of a DWI in Texas. Mr. Trayanone is pleading guilty, and the judge drops the hammer about the superfine or surcharge. A second DWI carries a mandatory $6,000 state surcharge on top of court fines, lawyer fees, and probation costs. The judge warns that for every $100 you don't pay, you sit a day in jail. That means a $6,000 fine could essentially convert into 2 months of jail time if you're broke. This plea deal involves giving up the right to confront accusers and appeal, sealing his fate. It's a sobering reminder that the cost of drunk driving isn't just moral or physical. It is financially ruinous for years to come.
Do not drive until you get a license. Good luck to you, sir.
Your Honor, just if I may mention, I just wanted to notify the court that we will be applying for
Occupational? Okay. Sure. Okay. I understand that you're going to have to, though, when you apply for an occupational license, you will have to do treatment. So, what we normally do is we have you do a TRAS, and then whatever the TRAS says is what you end up doing, and you have to get an interlock. So I don't know whether probation is something that you want, where I don't suspend your license, or whether you just want to do this, because you're going to undergo basically probation-esque terms regardless if we give you an occupation. So, okay?
Yes, sir.
Okay. All right. Good luck. Good morning, Mr. Is it Haran?
It's Aaron.
Heron? Ms. Heron, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Judge. This one was a 2B. On September 28th, 2024, a law enforcement officer was dispatched to a family disturbance at a residence in Harris County, Texas. The caller reported she observed the couple arguing in a truck, children crying, and heard a loud bang as if someone got struck in the head. The law enforcement officer observed the truck with one functioning headlight matching the description that was given him regarding the truck. The law enforcement officer observed a juvenile outside of the truck with red puffy eyes. The law enforcement officer made contact with defendant 1, Ms. Herron, and defendant 2. The defendant stated there was no altercation or arguments that occurred and that the law enforcement officer was talking to the wrong people and that they were okay. The law enforcement observed an odor of marijuana. The defendant's vehicle was sitting outside of a random residence at night, and the defendant stated the vehicle belonged to a friend.
Which defendant? Who?
I just said the defendant stated the vehicle belonged to a friend, and then there's defendant 1, which is referring to Ms. Herron for the next sentence. Ms. Herron refused to ID herself and stated she was going inside of the house. The law enforcement officer told defendant 1, Ms. Herron, to stay put until the conclusion of the domestic violence investigation. Defendant 2 exited the vehicle, stated, "No, I am not," when advised, and he was detained and pulled up his pants before getting in a bladed stance. The law enforcement officer grabbed the defendant 2's right wrist. Defendant 2 pulled away. The law enforcement officer grabbed defendant 2's shirt, telling him to stop as they fell to the ground. The defendant 1, Ms. Herron, pulled the law enforcement officer's arm and pushed the law enforcement officer's chest, preventing the law enforcement officer from restraining defendant 2. The law enforcement officer took out an electrical conducted weapon, told defendant 1 to get out of the way, Ms. Herron, and defendant 1 continued to refuse and push law enforcement officer's chest. Ms. Herron ID'd herself with her name and date of birth, which was confirmed with the Texas driver's license.
And we end with Miss Herron, who took the ride or die concept way too literally. She is charged with interference with public duties because she physically fought police officers to stop them from arresting her partner. The report details a chaotic scene, grabbing the officer's arm, pushing his chest, and refusing commands even when a taser was drawn. This is a felony-level mistake. Not only did her boyfriend get arrested anyway, since he had a warrant, but now she is facing a serious criminal charge herself. The judge separates them immediately with a no-contact order. It's a chaotic end to a chaotic docket.
Ms. Herron, don't. Now's not the time. You know, I've got a bunch of DAs here. Whatever you say, they're going to use it against you. You will have the opportunity to fight your case. Just now's not the time. I'm going to find that there's sufficient probable cause to go forward with the case. Do you have the ability to hire a lawyer, ma'am?
I don't.
Okay, we can have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you, how much money you make, what kind of job you have, and then we'll take a look to see whether you qualify. I see that the co-defendant in this case has a valid warrant for his arrest. I think that there's still a warrant open for his arrest. Also on a felony warrant as well. I'm ordering you as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? If you do, I'm going to put you in jail. No more PR bonds for you. Do you understand? Okay. So Deputy Miranda is going to give you an application. I'm going to have you go to Victoria, sign and reset, and then we'll have you take your seat in the jury box while you fill it out. Okay?
What a day in court. We saw everything from the tragic to the absurd. We watched a judge drop a legendary line about Jesus to stop a repeat drunk driver. We saw the high cost of failing to take a plea deal seriously. And we witnessed the legal system trying to handle everything from nitrous oxide addiction to crashing into trains. The key takeaway today: the court has zero tolerance for people who break their bond conditions. Whether it's smoking weed or driving a car when you've been told not to, the judge holds the keys to the jail cell, and he is not afraid to use them. If you found this case breakdown as shocking as we did, and if you want to see more strict judges handing out reality checks, make sure to hit that like button, share your thoughts on the rulings in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Stay safe, stay legal, and we'll see you in the next one.